Supreme Court today, in an important judgment, rejected a married woman's request to terminate her 26-week pregnancy, stating that the court could not approve an abortion request at this stage of pregnancy since there is no danger to the woman's life. The Supreme Court said the parents of the woman can make the decision on whether to give up the child for abortion, claiming that the pregnancy is of 26 weeks and 5 days and thus violates the Medical Terminacy Pregnancy Act. The apex court rejected the woman's petition. Anisha Mathur has more.
The Supreme Court attempting to strike a balance between the rights of a woman to choose what happens to her own body and the provisions of the MTP Act which proscribe that right depending on the gestational period of the pregnancy. The court making it clear that while in India women do have the right to choose, it is also prescribed and proscribed by the MTP Act itself. However, the Chief Justice also making it clear that the larger debate on pro-life and pro-choice angles that is going on in the rest of the world does not affect India because India has its own law. In New Delhi, with cameraman Jagannath, this is Anisha Mathur for India Today.
Let's get more details. I'm joined by one of the advocates who was in that case, Ameyavikrama Thanvi. Appeared on behalf of the centre in the Supreme Court. Ma'am, I want you to explain with greater detail what does the Supreme Court order mean when it rejects the plea of a married woman to abort her third pregnancy because it had crossed the 26-week mark. Can you explain why did the Supreme Court reject the plea and what does this order now mean in future for potential abortion cases?
So, thank you for having me. The Supreme Court order is essentially a reiteration of the law that we already have, which is the Medical Termination of Pregnancy Act, which is the statute that governs the entire law concerning abortion. Now, what the Supreme Court has said that we have a statute in place which permits abortion without any hindrance, without any questions, up to a certain limit. And beyond that time period, there are only two exceptions, which is there is a danger to the life of the fetus or of the mother. And in those exceptional circumstances beyond the period of 24 weeks, and a termination of pregnancy will be allowed.
So
that the Supreme Court has essentially balanced the right of the woman who is bearing the child and the child that is to be born.
So essentially you're saying that it will only be in exceptional circumstances after the 24-week period that an abortion will be allowed. To that extent, in that situation, the woman's freedom of choice is greatly reduced. Am I clear?
That would be a very broad statement. I wouldn't agree with that. The Supreme Court has said, like every other freedom, this freedom is also reasonably restricted. The Supreme Court has had to balance the rights here. See, even with right to life, it's not an absolute right. There is no right in our constitution which is absolute. We have that established. And in a democracy, statutes are a voice of the public, which essentially say what is the mandate of the public with regards to different issues. In this specific case, the right of a woman to choose what happens to her body has been upheld by the Supreme Court previously, and now only a clarification has come that this is not an absolute right.
But what it effectively means Ms. Thanvi, is because one of the lawyers argued in the court that an unborn child or an unborn fetus does not have overriding rights to life. The court seems to have rejected that and made it very clear that this right to life, while not being an absolute right, is subject to the rules of the Medical Pregnancy Termination Act. Am I correct?
Correct. In fact, the court clarified that we have our own law, and in the absence of a challenge to that law, and in the absence of striking down of that law, we have to act within the four corners of the law of the land as it exists.
But does that in a way circumscribe the term life under Section 5 of the Act? Because the court seems to have interpreted it that this cannot be decided by the pregnant woman. Am I right in saying that the right to choice, pro-choice activists will say this is limiting the right of the woman?
No, I will disagree with that. The court has essentially said that it is everything is see, ultimately it is after the examination of the woman, it was medical advice which governed the court's order. It's not a sweeping. There cannot be a sweeping generalization that in absolutely no case a woman will not be allowed to choose to terminate her pregnancy beyond a certain time limit. There are certain cases, there are certain exceptional circumstances prescribed within our statute, within our law, which still permit women to choose. But in this given case, it was in the light of the facts of the case and after examination by the medical board that the court reached its decision.
So very quickly in conclusion, the freedom of choice remains, but it cannot be absolute. Am I right? Broadly.
You are absolutely correct, sir. Freedom of choice remains, and it is ultimately a woman's choice to decide what she wants to do with her body.
Okay, thank you very much there for joining me. I appreciate you joining me there and giving us the perspective of that important judgment in the court.